Case number 1. Veronica Youngblood. The custody battle that ended in blood. McLean, Virginia. August 16, 2018. A 911 call shattered the evening calm of an upscale apartment complex. First responders rushed to the scene, expecting perhaps a medical emergency or a domestic dispute. What they found instead was a scene of carnage that would haunt even seasoned investigators for years to come. 15-year-old Sharon Castro lay dead, her young life stolen by gunfire. Her 5-year-old half-sister, Brooklyn Youngblood, clung to life, but would succumb to her injuries shortly after. The person responsible wasn't an intruder or a random act of violence. It was their own mother, Veronica Youngblood. The background of this tragedy reads like a textbook case of escalating domestic conflict. Veronica was embroiled in a bitter custody battle with her ex-husband, Ron Youngblood. Court documents painted a picture of a relationship that had deteriorated into acrimony and hostility. Ron had been granted custody of their daughter Brooklyn, a decision that Veronica contested vehemently. Friends and family members would later describe her as increasingly unstable, obsessed with the custody arrangement, and making disturbing comments about never letting her ex-husband win. On that fateful August evening, Veronica's resentment boiled over into something far more sinister. According to prosecutors, she armed herself with a firearm and made a calculated decision. If she couldn't have her children, neither could their father. It was a twisted logic that would cost 2 innocent girls their lives. Sharon, the eldest daughter from a previous relationship, was shot multiple times. Investigators believe she may have tried to protect her younger sister, based on the positioning of her body and defensive wounds. Little Brooklyn, just 5 years old, barely old enough to understand what was happening, was also shot. The medical examiner's report detailed the horrific nature of their injuries. Close-range gunfire that left no chance of survival. When police arrived, they found Veronica at the scene. She was arrested immediately and charged with 2 counts of first-degree murder, along with firearms offenses. The case that followed would captivate the Northern Virginia community and raise disturbing questions about how far a parent's rage could go. During the trial, which took place in Fairfax County Circuit Court, Veronica's defense team attempted an insanity plea. They argued that their client was suffering from severe mental illness at the time of the shootings, that she wasn't in control of her actions, and that she couldn't distinguish right from wrong. Mental health experts were called to testify about her psychological state, her history of emotional instability, and the pressure she felt from the custody battle. But prosecutors painted a very different picture. They presented evidence of premeditation. Text messages showed Veronica had been planning something ominous. She had purchased the firearm legally weeks before the murders. Witnesses testified that she had made statements suggesting she would rather see her children dead than with their father. This wasn't a spontaneous act of a mentally ill person, prosecutors argued. This was calculated murder driven by rage, jealousy, and a desire for revenge. The jury heard testimony from Ron Youngblood, who had to relive the nightmare of learning his daughter was gone and that the woman he once loved was responsible. They heard from Sharon's father, who lost his teenage daughter to senseless violence. They saw crime scene photos that were so disturbing, some jurors reportedly needed breaks during the proceedings. Expert witnesses debated Veronica's mental state. Defense psychiatrists diagnosed her with various conditions, including depression and possible personality disorders. But prosecution experts countered that mental illness doesn't equal insanity in the legal sense, and that Veronica knew exactly what she was doing when she pulled that trigger. The trial stretched over weeks, with emotional testimony and graphic evidence. The community watched closely, struggling to understand how a mother could do this to her own children. Finally, after days of deliberation, the jury returned with their verdict, guilty on both counts of first-degree murder. The sentencing phase brought more revelations. Impact statements from family members painted a picture of 2 vibrant young lives cut short. Sharon was described as a bright teenager with her whole future ahead of her, someone who loved her little sister and tried to be a good role model. Brooklyn was remembered as a bubbly 5-year-old who loved princesses and playing at the park, whose laughter would never be heard again. The judge handed down a sentence that reflected the severity of the crimes, up to 78 years in prison. At her age, it was effectively a life sentence. Veronica Youngblood would spend the rest of her days behind bars, with no possibility of walking free. The insanity defense had failed. The jury had seen through the arguments and found her criminally responsible for her actions. In the aftermath, questions lingered. Could this tragedy have been prevented? Were there warning signs that were missed? The custody battle had been contentious, but family courts see contentious cases every day. How do you identify which parent might actually cross the line from anger to violence? Mental health advocates pointed to the case as an example of how the system fails to adequately address severe mental illness in family court proceedings. But others argued that Veronica had access to resources, that she made choices, and that ultimately, she alone was responsible for picking up that gun. Today, Veronica Youngblood sits in a Virginia state prison, her appeals exhausted. 2 graves in Virginia cemeteries serve as permanent reminders of the 2 young girls who should still be alive, going to school, making friends, and living the lives they deserved. Their mother took all of that away in a moment of rage that can never be undone. This case stands as one of the most shocking instances of filicide, the murder of one's own children, in Virginia's recent history. It's a reminder that sometimes the greatest danger to children doesn't come from strangers, but from the very people who brought them into this world. If this case has affected you, please remember that resources are available for mental health support in domestic violence situations. And if you're finding value in these deep dives into true crime, don't forget to like this video, leave a comment with your thoughts, and hit that subscribe button so you never miss an episode of Cold Case Time. We're just getting started. Case number 2. Megan Hargan, the staged murder-suicide that fooled no one. McLean, Virginia, seems to appear repeatedly in our investigation, and our second case brings us back to this affluent community. On July 14, 2017, police responded to a home on Beach Mill Road for what initially appeared to be a tragic murder-suicide. What they discovered was a crime scene that would unravel into one of the most calculated and cold-blooded family annihilations in Virginia history. Inside the upscale home lay 2 bodies. 63-year-old Pamela Hargan and her 24-year-old daughter Helen Hargan were both dead from gunshot wounds. The initial scene suggested that Helen had shot her mother before turning the gun on herself. A rifle lay near Helen's body. There was a note. Everything seemed to point to a daughter in crisis who had committed an unspeakable act before taking her own life. But investigators weren't convinced. Something didn't add up. Megan Hargan, Pamela's other daughter and Helen's older sister, had been the one to discover the bodies, or so she claimed. She had called 911, hysterical, reporting the horrific scene. But as detectives began to dig deeper, the evidence started to tell a very different story. And at the center of that story was Megan herself. The Hargan family appeared, from the outside, to be living the American dream. Pamela was a successful career woman who had worked hard to provide for her daughters. The family lived in a beautiful home worth over $1 million. The girls had been given opportunities and advantages. But beneath the surface, there were fractures, secrets, and mounting financial pressure. Megan Hargan, it turned out, was in serious financial trouble. She had been living beyond her means, racking up debt, and making poor financial decisions. Her mother, Pamela, had been helping support her, but there were limits to that support. More troubling still, investigators discovered that Megan had been engaging in fraud, stealing money from her mother's accounts, and forging documents. In the months before the murders, Pamela had discovered some of Megan's deception. There were confrontations. Pamela was considering cutting Megan off financially and had discussed changing her will. For Megan, who had grown accustomed to her mother's financial support, this was unacceptable. She stood to inherit a substantial estate if her mother died, but only if she could make sure she wasn't disinherited first. The investigation revealed a chilling picture of premeditation. Forensic analysis of the crime scene showed that the murder-suicide scenario was staged. The angle of Helen's gunshot wound was inconsistent with self-infliction. The rifle's position didn't match what would be expected if Helen had shot herself. Gunshot residue patterns told a different story than the one Megan was trying to sell. But perhaps most damning was the digital evidence. In the days before the murders, there were financial transactions that raised red flags. Someone had been accessing Pamela's accounts, transferring money, and attempting to make it look like routine transactions. That someone was Megan. Investigators also discovered that Megan had been researching how to stage a suicide, looking up information about gunshot wounds and how crime scenes are processed. Her internet search history became a roadmap of her criminal intent. She had Googled questions about inheritance laws, about how quickly estates could be settled, and about whether life insurance paid out in cases of suicide. The timeline that emerged from the investigation was meticulous and horrifying. On that July day, Megan had gone to her mother's home armed with a rifle. Prosecutors believe she shot her mother first, likely catching Pamela by surprise. Then she turned the weapon on Helen, who may have witnessed her mother's murder or arrived home at the worst possible moment. After killing both women, Megan staged the scene to look like Helen had been the perpetrator. She positioned the rifle, created the appearance of a murder-suicide, and then likely left the house before discovering the bodies and calling 911. Her performance on the emergency call was designed to establish her innocence, to make her seem like the devastated family member who had stumbled upon an unthinkable tragedy. But investigators saw through it. As they built their case, more evidence mounted. Financial records showed Megan had attempted to access her mother's accounts almost immediately after the murders. She had forged her mother's signature on documents attempting to transfer significant sums of money. She had even tried to file life insurance claims within days of the deaths. The motive became crystal clear. Megan Hargan had murdered her mother and sister for money. It was greed in its purest, most evil form. And she had been willing to frame her dead sister as a murderer to cover her own tracks. Megan was arrested and charged with 2 counts of first-degree murder, along with multiple firearms offenses. She maintained her innocence, insisting that Helen was responsible and that she was being wrongly accused. Her defense attorneys argued that the evidence was circumstantial, that the prosecution couldn't definitively prove Megan had pulled the trigger, and that there were other possible explanations for what had happened. The trial was a spectacle that gripped the Northern Virginia community. Prosecutors presented a mountain of evidence: forensic analysis of the crime scene, expert testimony about the impossibility of the murder-suicide scenario, financial records showing Megan's theft and fraud, and digital evidence of her internet searches and planning. The defense tried to poke holes in the prosecution's case, suggesting that investigators had tunnel vision and had ignored other possibilities. They brought in their own experts to challenge the forensic findings. But the evidence was overwhelming. One of the most emotional moments of the trial came when prosecutors presented the timeline of Megan's actions after the murders. While her mother and sister lay dead, Megan was making phone calls about money, accessing accounts, and planning how to profit from their deaths. The cold-blooded nature of her actions, the complete lack of remorse or grief, shocked even hardened court observers. Text messages between Megan and friends after the murders showed her expressing concern not about her dead family members, but about her financial situation and whether she would receive her inheritance. She had been planning a trip, making purchases, and living her life as if she hadn't just committed double murder. The jury deliberated and reached a verdict: guilty on both counts of first-degree murder. The evidence had been too strong, the premeditation too clear. Megan Hargan had murdered her own mother and sister in cold blood for financial gain. At sentencing, the judge heard impact statements from extended family members and friends who had lost 2 beloved women. They spoke of Pamela's generosity, her hard work, and her love for her daughters. They remembered Helen as a young woman with her whole life ahead of her, someone who had done nothing to deserve such a brutal end. And they expressed their horror that Megan, a member of their own family, could commit such evil acts. The sentence was severe and final: 2 consecutive life sentences, plus additional time for the firearms charges. Megan Hargan would never see freedom again. She would spend the rest of her life in prison, thinking about the mother and sister she murdered for money she would never get to spend. Appeals followed, as they often do in such cases. Megan continued to maintain her innocence, her attorneys filing motions and challenging various aspects of the trial. But the convictions held. The evidence was simply too strong to overcome. What makes the Megan Hargan case particularly chilling is the calculated nature of the crimes. This wasn't a crime of passion, a moment of rage that spiraled out of control. This was planned, researched, and executed with cold precision. Megan had time to stop, to reconsider, to choose a different path. But at every decision point, she chose murder. Psychologists who have studied the case note that Megan displayed traits consistent with narcissistic personality disorder and psychopathy. Her ability to kill her own family members, and then immediately focus on accessing their money suggests a profound lack of empathy or conscience. She viewed her mother and sister not as human beings with intrinsic worth, but as obstacles to her financial goals. The case also highlights the dangers of financial desperation and entitlement. Megan had grown up with privilege, but instead of appreciating it, she felt entitled to more. When her mother threatened to cut her off, she chose murder rather than face the consequences of her own poor decisions and fraudulent behavior. Today, Megan Hargan remains in prison, her appeals exhausted. Pamela and Helen Hargan are buried side by side, two lives stolen far too soon by someone who should have loved and protected them. The beautiful home on Beach Mill Road where they died has since been sold, but the horror of what happened there will never be forgotten. If this case has disturbed you as much as it has me, take a moment to process it. And if you appreciate the depth of research we put into each case here at Cold Case Time, show your support by hitting that like button, dropping a comment about your thoughts on this case, and subscribing to our channel for more true crime investigations that go beyond the headlines. Case number 3, Leandra Andrade, death by Benadryl. Virginia Beach, Virginia. June 9, 2022. Emergency responders rushed to a home where a 2-year-old child had been found unresponsive. Little Leandra Andrade was rushed to the hospital, but tragically, she could not be saved. What initially appeared to be a sudden and unexplained medical emergency would soon reveal itself to be something far more sinister. The autopsy results were shocking. Leandra had toxic levels of diphenhydramine in her system, the active ingredient in Benadryl. The concentration was so high that it could only have resulted from a massive overdose. This was not an accidental ingestion of a medicine left within a child's reach. The amount in her tiny body suggested deliberate administration of a dangerous quantity of the drug. Investigators turned their attention to Leandra Andrade, Leandra's mother. What they uncovered was a troubling pattern of behavior and a history that raised serious red flags about the child's care and safety. Leandra had a documented history of mental health issues. Friends and family members reported that she had been struggling, that her behavior had become increasingly erratic, and that there were concerns about her ability to care for her daughter. But the mental health system, stretched thin and often reactive rather than proactive, had not intervened in time to save Leandra. As police built their case, they discovered evidence that Leandra had been giving her daughter Benadryl regularly, possibly to keep her sedated and quiet. Bottles of the medication were found in the home, and witnesses reported seeing Leandra giving Leandra's medicine frequently, more often than would be appropriate for a child's typical ailments. The investigation revealed that in the days leading up to Leandra's death, Leandra's mental state had deteriorated significantly. She had made statements to people that didn't make sense, exhibited paranoid behavior, and seemed disconnected from reality. Some who knew her suspected she might be experiencing psychosis or a severe mental health crisis. On June 9th, for reasons that may never be fully understood, Leandra gave her daughter a fatal dose of medication. Whether it was a deliberate act of murder, a misguided attempt to calm her child that went horribly wrong, or the action of someone so mentally ill she couldn't comprehend what she was doing became the central question of the legal proceedings that followed. Leandra Andrade was arrested and charged with aggravated murder and child neglect. The charges carried the possibility of life in prison. But as the case moved through the legal system, the question of her mental competency came to the forefront. Defense attorneys argued that Leandra was not mentally fit to stand trial, that she had been suffering from severe mental illness at the time of her daughter's death, and that she lacked the capacity to understand the nature and consequences of her actions. They presented evidence of her psychiatric history, testimony from mental health professionals, and documentation of her deteriorating mental state. Psychiatric evaluations were ordered. Multiple experts examined Leandra, reviewing her medical records, interviewing her, and assessing her mental state both at the time of the offense and in the present. The evaluations painted a picture of a woman with serious mental health disorders that had gone inadequately treated. The legal question at the heart of the case was whether Leandra could be held criminally responsible for her actions. Virginia, like most states, has provisions for the insanity defense, but it's a high bar to clear. Defendants must prove that at the time of the crime, due to mental illness, they either didn't know what they were doing was wrong or couldn't control their behavior. Prosecutors faced a difficult decision. The evidence clearly showed that Lenoix had died from a massive overdose of medication administered by her mother. But proving that Leandra had the criminal intent required for a murder conviction would be challenging given her documented mental illness. In a development that divided public opinion, the judge accepted a plea of not guilty by reason of insanity. This meant that while Leandra was responsible for her daughter's death, she was not criminally culpable due to her mental state at the time. Instead of prison, she would be committed to a psychiatric facility. The decision sparked debate in the Virginia Beach community and beyond. Some saw it as the right outcome, acknowledging that mental illness had played a central role in this tragedy and that Leandra needed treatment, not punishment. Others were outraged, feeling that a mother who had killed her child should be in prison, regardless of mental health issues. Under Virginia law, defendants found not guilty by reason of insanity are committed to state mental health facilities. They can potentially be released if they're deemed no longer a danger to themselves or others, but only after rigorous evaluations and court proceedings. It's not a get-out-of-jail-free card, as some critics claim, but rather a different form of custody focused on treatment rather than punishment. Leandra Andrade was committed to a secure psychiatric facility. She remains there now, undergoing treatment for her mental health conditions. A conditional release hearing has been scheduled for March 2026, where mental health professionals and the court will determine whether she has been successfully treated and whether she poses a risk if released. The conditions of any potential release would be strict. She would likely face years of supervised probation, mandatory mental health treatment, and restrictions on her freedom. And she would have to live with the knowledge that her daughter is dead because of her actions, even if those actions were driven by mental illness. The case raises profound questions about the intersection of mental health and the criminal justice system. How do we balance accountability with compassion? When does mental illness excuse criminal behavior, and when should it not? What responsibility does society bear for identifying and treating people with severe mental health issues before tragedy strikes? Lenoix's father and other family members have had to grapple with an impossible situation. Their loved one is gone, killed by her own mother. Do they seek vengeance or understanding? How do they process grief when mental illness is so clearly a factor? Advocates for mental health reform point to cases like this as evidence that the system is broken. Leandra had documented mental health issues, yet she was still the primary caregiver for a vulnerable child. Were there opportunities for intervention that were missed? Could social services, mental health professionals, or family members have done more to prevent this tragedy? Critics of the insanity defense argue that it allows people to literally get away with murder by claiming mental illness. They point out that many people have mental health issues and don't kill their children, and that accepting mental illness as an excuse sets a dangerous precedent. The truth, as is often the case, is more complex than either extreme position. Mental illness is real, and it can profoundly affect behavior and decision-making. But it also doesn't absolve individuals of all responsibility, and society has a right to protect itself from dangerous individuals, regardless of their mental state. What is undisputed is that a 2-year-old child is dead, a child who should be alive today, playing, learning, and growing. Lenoix Andrade never got to start school, never got to make friends, never got to experience all the joys and challenges of childhood. Her life was cut short by a toxic dose of medication administered by the person who should have been protecting her. As we await the 2026 conditional release hearing, questions remain about what justice looks like in a case like this. Is psychiatric treatment sufficient accountability for a child's death? Should Leandra Andrade ever be free? Or does taking her daughter's life mean she should remain confined, whether in prison or a psychiatric facility, for the rest of her life? These are questions without easy answers. But they're questions we must grapple with as a society as we try to balance punishment, treatment, public safety, and human compassion. This case reminds us that mental health is not something to be ignored or stigmatized. Warning signs should be taken seriously, and people in crisis need intervention before tragedy strikes. If you or someone you know is struggling with mental health issues, please seek help. Resources are available, and asking for help is a sign of strength, not weakness. If you're finding these deep dives into Virginia's most disturbing cases informative, please let us know by hitting that like button. Drop a comment sharing your thoughts on this complex case, and don't forget to subscribe to Cold Case Time so you stay updated on our investigations into the crimes that shake our communities. Case number 4. Tiara Jefferson, the gunshot that ended everything. Henrico, Virginia. November 2, 2018. A 911 call reported that a 4-year-old boy had been shot inside his home. When police and paramedics arrived at the residence, they found young Demetrius Jefferson suffering from a gunshot wound. Despite desperate attempts to save him, the little boy died from his injuries. The investigation that followed would uncover a heartbreaking story of neglect, questionable circumstances, and a mother whose version of events didn't match the evidence. Tiara Jefferson told investigators that the shooting was an accident, that somehow her son had accessed a firearm and shot himself. But the evidence suggested something else entirely. Demetrius was just 4 years old, barely old enough for preschool. At that age, children should be playing with toys, learning their ABCs, and enjoying the innocence of early childhood. Instead, Demetrius was in a home where firearms were accessible, where supervision was apparently lacking, and where his safety was not adequately protected. When investigators examined the scene and Tiara's statements, inconsistencies began to emerge. The positioning of the gun, the nature of the wound, and the circumstances described by Tiara didn't add up. Forensic experts analyzed the evidence, looking at trajectory, gunshot residue, and the physical impossibility of some of the scenarios Tiara had described. Child Protective Services had a history with the Jefferson family. There had been prior concerns about the children's welfare, reports of inadequate supervision, and questions about whether the home environment was safe. But as too often happens in an overburdened system, intervention had been limited, and the children had remained in Tiara's care. The question facing investigators was whether this was truly an accident, a horrific tragedy resulting from negligence and poor judgment, or whether something more sinister had occurred. Had Tiara deliberately shot her son? Or had she created such a dangerous environment through her neglect that his death was inevitable? Tiara Jefferson was initially charged with second-degree murder, child abuse, and child neglect resulting in serious injury. The charges reflected the severity of the situation and the belief that her actions, whether through commission or omission, had led directly to her son's death. As the case proceeded through the legal system, Tiara's defense attorneys worked to negotiate a resolution. The evidence against her was strong, but proving intent for a murder conviction would be challenging. The prosecution had to weigh their chances at trial against the certainty of a guilty plea to lesser charges. In a move that sparked controversy and anger from those who knew little Demetrius, Tiara entered an Alford plea. This unusual type of plea allows a defendant to maintain their innocence while acknowledging that the prosecution has enough evidence to likely secure a conviction. Essentially, it's a way of saying, I don't admit I did this, but I recognize that a jury would probably find me guilty. Under the terms of the plea agreement, the murder charges were set aside, dropped in exchange for Tiara pleading to child abuse resulting in serious injury. The original charges had carried the potential for decades in prison. The negotiated charges carried a significantly lighter sentence. When Tiara Jefferson appeared for sentencing, the courtroom was filled with emotion. Family members who had loved Demetrius spoke about the bright, energetic boy who would never get to grow up. They talked about his smile, his laughter, and the hole his death had left in their lives. They struggled with the plea agreement, feeling that justice was not truly being served. The judge sentenced Tiara to just 6 months in jail, with additional suspended time and probation. 6 months for the death of a 4-year-old child. The sentence shocked many observers and led to public outcry about whether the justice system had failed Demetrius. Advocates for children's rights and safety pointed to the case as an example of how child victims are sometimes given less consideration than adult victims in the criminal justice system. Would the same plea deal and sentence have been offered if Tiara had caused the death of an adult through similar neglect and recklessness? Many believe the answer was no. The light sentence sparked conversations about accountability for parents whose neglect leads to children's deaths. Where is the line between a tragic accident and criminal negligence? When should parents be held to a higher standard because of their duty to protect their vulnerable children? Child welfare advocates also highlighted the case as evidence of systemic failures. Warning signs had been present in the Jefferson home. Prior CPS involvement, concerns about the children's safety, and a home environment that clearly had issues, yet the system had not removed the children or provided adequate intervention. Demetrius had paid for those failures with his life. The circumstances of the shooting remained somewhat murky. Tiara's version of events, the physical evidence, and the testimony of investigators didn't fully align. Some questions about exactly what happened in that home on November 2, 2018, may never be definitively answered. But what is certain is that a 4-year-old boy died from a gunshot wound in a home where firearms were not properly secured and where adult supervision was inadequate. After serving her 6 months, Tiara Jefferson was released. She faced years of probation and various conditions of release, but she walked free while her son lay in a grave. The disparity between her crime and her punishment continues to anger those who believe justice was not served. The case highlights the challenges of prosecuting child abuse and neglect cases that result in death. Proving intent can be difficult. Juries can be sympathetic to parents, even in terrible circumstances. And prosecutors sometimes feel that a certain conviction on lesser charges is preferable to the risk of acquittal if they push for the most serious charges. But for those who love Demetrius, these legal calculations offer little comfort. A child is dead, a child who should still be here, who would be 10 years old now if he had been given the chance to grow up. He should be in elementary school, making friends, learning to read, and experiencing all the wonder that childhood offers. Instead, Demetrius Jefferson is gone, another child victim of parental neglect and violence. His case stands as a reminder that the greatest danger to children often comes not from strangers or random violence, but from the very people entrusted with their care. The broader implications of the case continue to resonate. How can society better protect children in homes where neglect and danger are present? What reforms are needed in child protective services to prevent tragedies like this? And how should the justice system balance mercy and accountability when parents' actions lead to their children's deaths? These questions don't have easy answers, but they're questions we must continue to ask. Every child deserves safety, protection, and the chance to grow up. When we fail to provide that, and when children like Demetrius pay the ultimate price, we must demand better from our systems and from ourselves. If this case has moved you, consider supporting organizations that work to protect children and reform child welfare systems. And let us know your thoughts by liking this video, leaving a comment about how we can better protect vulnerable children, and subscribing to Cold Case Time for more investigations into the cases that demand our attention and action. Case number 5. Amy FaJohn. Starvation in the Shadow of Abundance. Hopewell, Virginia. December 15, 2018. First responders arrived at a home to find a 13-year-old boy in a condition that shocked even experienced medical professionals. Jalen FaJohn was emaciated, his body ravaged by prolonged starvation. He weighed just 42 pounds, less than half the normal weight for a boy his age. He was barely conscious, his organs shutting down from malnutrition. Despite desperate efforts to save him, Jalen died shortly after arriving at the hospital. The cause of death was clear: starvation. In America, in the 21st century, in a home where there was food and resources, a 13-year-old child had been allowed to starve to death. Jalen wasn't just any 13-year-old. He was disabled, nonverbal, and completely dependent on his mother, Amy FaJohn, for his basic needs. He couldn't feed himself, couldn't ask for food, couldn't escape his situation. He was entirely at his mother's mercy, and his mother showed him none. The investigation revealed a horror that's difficult to comprehend. Jalen had been systematically neglected for an extended period. Medical examiners determined that his starvation hadn't happened overnight. It had been ongoing for weeks or months. His body showed signs of chronic malnutrition, bed sores from lying in the same position for too long, and evidence of profound neglect. Other children lived in the home, and they were not starving. Food was present in the house. Amy FaJohn was feeding herself and others. But somehow, she was not feeding Jalen, her disabled son who depended on her completely for survival. When investigators interviewed Amy, she offered excuses that rang hollow. She claimed Jalen had eating difficulties, that he refused food, that she had tried to feed him, but he wouldn't cooperate. But medical experts quickly debunked these claims. A child doesn't reach 42 pounds because they're a picky eater. A child reaches that state because they're not being fed, period. Further investigation uncovered that Amy had been receiving government assistance specifically to care for Jalen due to his disabilities. She was receiving money meant to provide for his special needs, to ensure he had proper nutrition and care. Instead, that money was being spent on other things while Jalen slowly starved. The condition of Jalen's body told the story his voice never could. He had bed sores indicating he had been left lying in one position for extended periods. His muscles had atrophied from malnutrition. His internal organs had begun to fail. The medical examiner's report detailed the systematic nature of the neglect and the prolonged suffering Jalen had endured. Neighbors later reported that they rarely, if ever, saw Jalen. He was kept hidden away, isolated in the home. Some had wondered about him, had asked Amy about her son, but had been given vague responses about his health or well-being. No one had suspected the truth, that he was being slowly starved to death just yards from where they lived. School records showed that Jalen had been withdrawn from the educational system, supposedly for homeschooling due to his disabilities. This removed one of the most common safety nets for vulnerable children, teachers and school staff who might notice signs of abuse or neglect. Once Jalen was out of the school system, he became invisible, and his suffering went unobserved. Amy FaJohn was arrested and charged with first-degree murder and felony child neglect. The charges reflected the severity of what she had done, or more accurately, what she had failed to do. By withholding food from her disabled, dependent son, she had effectively murdered him, and she had done it slowly, over a period of time that allowed for countless opportunities to stop, to change course, to choose compassion over cruelty. As the case moved through the legal system, prosecutors faced a decision about how aggressively to pursue the charges. First-degree murder requires proving premeditation, that Amy had formed the intent to kill her son and carried it out deliberately. Could they prove that, or was this a case of extreme neglect rather than murder? The evidence supported a murder charge in many ways. Jalen's starvation had been ongoing for so long that Amy had to have been aware of what was happening. Every day that she fed herself and others while denying food to Jalen was a choice. Every day that she saw his deteriorating condition and did nothing was a decision. The systematic nature of the neglect suggested intent. But Amy's defense team argued for a different interpretation. They painted Amy as an overwhelmed mother struggling with the challenges of caring for a severely disabled child, someone who had made terrible mistakes but hadn't intended to kill her son. They sought to have the charges reduced. In a development that disappointed many who had followed the case, Amy FaJohn entered a no-contest plea to a lesser charge. The first-degree murder charge was dropped in exchange for her plea to second-degree murder and child neglect. A no-contest plea, similar to an Alford plea, allows a defendant to accept punishment without formally admitting guilt. The plea deal was controversial. Advocates for disabled children and child welfare organizations argued that Amy should have faced the full weight of the law for what she had done to Jalen. They pointed out that Jalen had suffered immensely, that his death had been slow and agonizing, and that Amy had had countless opportunities to seek help, to feed her child, to choose life over death. At the sentencing hearing, the judge heard impact statements from those who had known Jalen. Teachers who had worked with him before he was withdrawn from school described a child who, despite his disabilities, had shown personality and responsiveness. Family members spoke about the tragedy of his death and the betrayal of trust that Amy had committed. The judge sentenced Amy FaJohn to 20 years in prison, with an additional 20 years suspended, meaning she would serve a maximum of 20 years if she complied with conditions afterward. While this was a substantial sentence, many felt it was insufficient for the prolonged torture of starving a disabled child to death. The case raised critical questions about how we protect the most vulnerable members of society. Disabled children, particularly those who are nonverbal and dependent, are at heightened risk for abuse and neglect. They can't report what's happening to them. They can't ask for help. They rely entirely on the adults in their lives to provide care and protection. Jalen's case also highlighted failures in the systems designed to protect children. He had been withdrawn from school, removing one layer of oversight. Child Protective Services had not been monitoring the family, despite Jalen's vulnerability. The agencies distributing assistance for his care hadn't checked to ensure he was actually receiving that care. Multiple systems had failed, and Jalen had paid with his life. The disability rights community pointed to the case as an example of how society devalues disabled lives. Would a non-disabled 13-year-old starvation death have resulted in a plea deal and a reduced sentence? Many believe the answer was no, that Jalen's disabilities had made his life seem less important to the justice system. Research shows that children with disabilities are at significantly higher risk for abuse and neglect than their non-disabled peers. They're more dependent, sometimes more challenging to care for, and often more isolated from community oversight. Cases like Jalen's underscore the need for better protection, monitoring, and support for these vulnerable children and their families. Some observers noted that if Amy had been struggling to care for Jalen, resources were available. She could have sought respite care, social services support, or even voluntarily placed him in a care facility if she truly couldn't meet his needs. The fact that she instead chose to let him starve while collecting money meant to support his care suggested that her crime was one of selfishness and callousness rather than desperate circumstances. Today, Amy FaJohn sits in a Virginia prison. Jalen FaJohn lies in a grave, a child who experienced suffering that should never be allowed to happen. His short life was marked by vulnerability and dependence, and the person who should have protected him most was the one who killed him. The legacy of Jalen's case is a call to action. We must do better at protecting disabled children. We must have systems in place to monitor vulnerable children, especially those withdrawn from school or isolated in homes. We must train professionals to recognize signs of abuse and neglect. And we must send a message that disabled lives matter, that their worth is equal to any other life, and that those who harm them will face serious consequences. If Jalen's story has affected you, consider how you can help protect vulnerable children in your community. Support organizations that work with disabled children. Be alert to signs of abuse or neglect. Speak up when something doesn't seem right. We all have a role to play in ensuring that no child suffers as Jalen did. Please show your support for this kind of in-depth coverage by hitting the like button, leaving a comment about how we can better protect disabled children, and subscribing to Cold Case Time to make sure you never miss an investigation that matters. Case number 6. Helena Little, the stabbing in Reston, Virginia. September 2024. Police responded to a home in this quiet Northern Virginia community for a reported stabbing. What they found was a scene of violence that would shock the neighborhood. A 79-year-old woman, Norma Little, had been stabbed to death in her own home. The person accused of this brutal crime was her own daughter, Helena Little. Unlike some of the other cases we've examined today, Helena Little's case is still working its way through the justice system. She has been charged with second-degree murder and is awaiting trial. As such, she's entitled to the presumption of innocence, and the full facts of what happened that day may not emerge until the trial takes place. But what we know so far paints a disturbing picture. Norma Little was a 79-year-old woman in the later years of her life. By all accounts, she was living in the Reston area, and family dynamics were part of her daily reality. Her daughter, Helena, was an adult woman who had some connection to her mother's household. The exact nature of their relationship and living situation is part of what investigators have been examining. On that September day, something went terribly wrong. According to charging documents and police reports, there was an altercation between Helena and Norma. The situation escalated, and at some point, Norma was stabbed. The wounds were severe, and despite any emergency response, Norma died from her injuries. Helena Little was arrested at the scene or shortly thereafter and charged with second-degree murder. Second-degree murder, as opposed to first-degree, generally means that while the killing was intentional, it wasn't premeditated. It's often applied in cases where a confrontation or fight escalates into deadly violence, but where there's no evidence the killer had planned the murder in advance. The investigation into what led to the stabbing has been ongoing. Detectives have been interviewing witnesses, examining the crime scene, and building a timeline of events. They've likely been looking into the history between Helena and Norma, whether there had been prior conflicts, and what might have triggered the fatal altercation. Family dynamics in cases like this are often complex. Adult children living with or caring for elderly parents can face stress, conflict, and challenges that sometimes escalate. Financial issues, caregiving burdens, personality conflicts, mental health issues, or substance abuse can all contribute to volatile situations. We don't yet know which, if any, of these factors were present in the Little family. What we do know is that a 79-year-old woman is dead, allegedly killed by her own daughter. Norma Little should have been able to spend her later years in peace and safety, perhaps surrounded by family, enjoying retirement, and living out her days in comfort. Instead, Her life ended in violence at the hands of someone she had brought into the world. Helena Little has been held in the Fairfax County jail system since her arrest. She has appeared in court for preliminary hearings, where prosecutors have presented enough evidence to proceed with the case. Her defense attorneys have been working to build their case, though the details of their strategy have not been made public. The case has been scheduled for trial, where a jury will hear all the evidence and determine whether Helena is guilty of second-degree murder. Prosecutors will need to prove beyond a reasonable doubt that Helena intentionally killed her mother. The defense will have the opportunity to present their version of events, potentially arguing self-defense, accident, or some other mitigating factor. One aspect that makes this case particularly tragic is the age of the victim. Elderly individuals are often vulnerable, unable to defend themselves effectively against younger, stronger attackers. If Helena did indeed stab her 79-year-old mother to death, it represents an attack on someone who had little ability to fight back or escape. Elder abuse is a growing concern in America as the population ages. While we often think of elder abuse happening in nursing homes or at the hands of caregivers, family members are actually the most common perpetrators. Adult children who are struggling financially, dealing with addiction, or facing mental health challenges sometimes turn on their elderly parents in tragic ways. The Reston community where this crime occurred is known for being a relatively safe, planned community in Northern Virginia. Violent crime, particularly within families, is not common there. The case has shaken residents and raised concerns about what might be happening behind closed doors in seemingly normal households. As we await trial, many questions remain unanswered. What was the relationship between Helena and Norma like in the days and weeks before the stabbing? Had there been warning signs that violence was possible? Were there prior incidents of conflict or abuse? What exactly happened in those moments when the situation turned deadly? The legal proceedings will hopefully answer some of these questions. Trials serve not just to determine guilt or innocence, but to establish a public record of what happened and why. For Norma Little's extended family and friends, the trial may provide some answers and some sense of closure, though nothing can bring Norma back. If convicted, Helena Little faces a significant prison sentence. Second-degree murder in Virginia carries a sentence of 5 to 40 years, with the exact term depending on the circumstances of the crime and the defendant's background. Given that the victim was her elderly mother, and given the violent nature of the crime, a lengthy sentence would be likely. The case is a reminder that family violence doesn't discriminate by age. We often focus on child abuse or domestic violence between partners, but elder abuse, particularly violence against elderly parents, is a real and growing problem. As a society, we need to be more aware of the warning signs and more willing to intervene when we suspect that elderly individuals are at risk. For now, Helena Little sits in jail awaiting her day in court. Norma Little lies in a grave, her life cut short by alleged violence at the hands of her own daughter. The justice system will determine Helena's fate, but no verdict can undo the tragedy or bring Norma back to the family and friends who loved her. We'll continue to follow this case as it proceeds through trial. If you want to stay updated on the outcome and on other developing true crime cases in Virginia, make sure you're subscribed to Cold Case Time. Hit that like button if you appreciate our coverage of both historical and developing cases, and leave a comment with your thoughts on this tragic situation. Case number 7. Heather Cummings, death at the nursing home. Norfolk, Virginia. Summer 2024. At a senior living facility in this coastal city, 81-year-old Cleo Loizides was found dead under suspicious circumstances. What should have been a place of care and safety for an elderly woman had become the scene of her murder, and the person responsible, according to prosecutors, was her own daughter, Heather Cummings. The case began with what appeared to be a death that might have been natural, an 81-year-old woman in a nursing home passing away. But medical staff and investigators quickly realized that something was wrong. The circumstances of Cleo's death didn't match a natural passing, and suspicions were raised that led to a full homicide investigation. Cleo Loizides had been a resident at the Norfolk Senior Living Facility, likely requiring care and assistance that her family couldn't provide at home. These facilities are supposed to be safe havens for elderly individuals, places where they receive professional care and can live out their final years in comfort and dignity. But for Cleo, the facility became the place where her life would end at the hands of someone she trusted. The investigation revealed that Heather Cummings had visited her mother at the facility regularly. On one of these visits, something went terribly wrong. According to the case against her, Heather killed her mother while at the facility. The exact method and circumstances of the killing became central to the prosecution's case. What makes this case particularly disturbing is that it occurred in what should have been a protected environment. Nursing homes and senior living facilities have staff, security, and oversight. The fact that a murder could occur there raises questions about monitoring and protection of vulnerable residents. Adding another layer to the case, Heather didn't act alone. Her son, Cleo's grandson, was also involved in the crime. The case became one of multiple family members allegedly conspiring to kill an elderly woman who should have been able to trust her own family to protect and care for her. The investigation uncovered evidence that pointed to premeditation. This wasn't a spontaneous act of violence, but something that had been planned. The involvement of both Heather and her son suggested coordination and discussion beforehand about what they were going to do. Motives in cases like this often involve financial gain, inheritance, or a desire to stop providing care for an elderly relative. While the specific motive in Heather's case hasn't been fully disclosed, investigators likely explored whether there were life insurance policies, inheritance issues, or other financial incentives for Cleo's death. When confronted with the evidence against her, Heather Cummings made a decision that many defendants in her position make. She chose to accept a plea deal rather than face trial. She pleaded guilty to second-degree murder, acknowledging her role in her mother's death in exchange for a negotiated sentence. The guilty plea meant that the full details of what happened that day at the Norfolk facility might never be publicly aired. Trials bring out evidence, testimony, and a complete narrative of events. Plea deals, while providing certainty and closure, often leave questions unanswered about exactly what occurred and why. At her sentencing hearing in late 2024, Heather Cummings faced the consequences of her actions. The judge heard arguments from prosecutors about the severity of the crime. A daughter murdering her elderly, vulnerable mother in what should have been a place of safety. The defense likely argued for leniency, perhaps pointing to mitigating factors or Heather's acceptance of responsibility through her guilty plea. The judge sentenced Heather Cummings to 40 years in prison. At her age, it's effectively a life sentence, ensuring that she will spend the rest of her days behind bars for what she did to her mother. The sentence reflected the seriousness of the crime and the betrayal of trust inherent in a child killing their elderly parent. Her son, who was also involved in the crime, faced his own legal proceedings. The disposition of his case and his sentence would have been determined separately, but his involvement underscored the family nature of this tragedy, multiple generations conspiring against the eldest generation. The case sent shockwaves through the Norfolk community and raised concerns among families who have loved ones in nursing homes. How could this happen in a facility with staff and oversight? What safeguards failed? And how can families trust that their elderly relatives are safe in these facilities? Senior living facilities across the country have faced increasing scrutiny about security and protection of residents. While most facilities work hard to provide safe, caring environments, cases like this highlight the potential for abuse and harm, even in supposedly monitored settings. Cleo Loizides was 81 years old when she died. She had lived a long life, raised children, had grandchildren, and should have been allowed to live out her remaining years in peace. Instead, her own daughter decided that Cleo's life should end and carried out that decision with the help of Cleo's own grandson. The psychological impact of such a betrayal is difficult to comprehend. Did Cleo know what was happening? Did she realize her own daughter was killing her? Did she have a moment to wonder why? To feel the profound hurt of such a betrayal? These are questions that haunt cases of familial violence. The case also highlights issues around elder care and the stress it can place on families. Caring for elderly parents, particularly those with significant health issues or dementia, can be emotionally, physically, and financially draining. While this never excuses violence, it's a reality that contributes to tensions and conflicts in many families. Resources exist to help families dealing with the challenges of elder care. Respite care, support groups, financial assistance programs, and counseling are all available. But too often, families don't seek help until it's too late, until stress and resentment have built to dangerous levels. Heather Cummings had options other than murder. She could have asked for help with her mother's care. She could have explored different living arrangements. She could have sought counseling to deal with whatever emotions or issues were driving her actions. Instead, she chose violence, and her mother paid the ultimate price. Today, Heather Cummings sits in a Virginia prison, serving her 40-year sentence. Cleo Loizides is buried, her life stolen by someone who should have loved and protected her. The nursing home where it happened continues to operate, but the shadow of what occurred there lingers. For families with loved ones in nursing homes or considering such placement, this case is a sobering reminder to stay involved, to visit regularly, to ask questions, and to be vigilant about signs of abuse or neglect, whether from staff or from other family members. If this case has resonated with you, particularly if you have elderly parents or relatives, take a moment to check in on them. And if you value the work we do here at Cold Case Time to bring attention to these important cases, show your support by liking this video, commenting with your thoughts, and subscribing to our channel for more true crime coverage. Case number 8. Elizabeth Renee Ott, the Microwave Horror. New Kent County, Virginia, 2005. This case takes us back over 2 decades to one of the most disturbing child death cases in Virginia history. The details are so horrific that they're difficult to even speak about, but it's a case that must be remembered, both as a warning and as a memorial to an innocent life lost in the most unthinkable way. Elizabeth Renee Ott was a young mother with an infant son. What should have been a time of joy and bonding became instead a nightmare that would shock investigators and haunt a community for years. Her infant son died, and the cause of death was so unusual and so horrifying that it initially seemed impossible. The baby had been placed in a microwave oven and turned on. The injuries were consistent with microwave radiation and heat exposure. It's a method of killing so unusual and so cruel that it defies understanding. How could a mother do such a thing to her own helpless infant? The investigation into the baby's death was complex. Determining exactly what had happened required forensic pathology expertise, analysis of the injuries, and reconstruction of events. The evidence pointed unmistakably to the microwave as the cause of death, but the question of how and why this occurred required deeper investigation. When confronted with the evidence, Elizabeth Renee Ott was faced with serious criminal charges. The prosecution had evidence that her infant son had died in her care under circumstances that could only be described as homicide. The case against her was strong, but as with many criminal cases, there were considerations about mental state, intent, and the strength of evidence that would be presented to a jury. In a controversial legal maneuver, Elizabeth entered what's known as an Alford plea. This type of plea, which we've seen in other cases in this documentary, allows a defendant to maintain their innocence while acknowledging that the prosecution has sufficient evidence for a conviction. It's a strategic decision that avoids the risk of a trial while not requiring a formal admission of guilt. Under the terms of the plea agreement, Elizabeth pleaded to manslaughter rather than murder. Manslaughter carries a lighter sentence than murder and implies that the killing, while unlawful, was not premeditated or intended. The legal distinction can seem like semantics when the result is a dead infant, but in the criminal justice system, these distinctions matter significantly. The plea deal was controversial at the time and remains so today. Critics argued that what happened to that baby was clearly murder, that the act of placing an infant in a microwave and turning it on cannot be anything but intentional and knowing. How could this possibly be reduced to manslaughter? Defenders of the plea, including prosecutors who agreed to it, likely faced evidentiary challenges. Proving exactly what was in Elizabeth's mind at the time, proving premeditation, and convincing a jury beyond a reasonable doubt of murder charges might have been difficult. Taking a certain conviction on manslaughter might have seemed preferable to the risk of acquittal. Elizabeth Renee Ott was sentenced to 5 years in prison for manslaughter. 5 years for the death of her infant son in one of the most horrific methods imaginable. She served her time and was released years ago. Today, she's living somewhere as a free woman, having paid what the legal system determined was her debt to society. The case raises profound questions about justice and proportionality. Is 5 years an adequate punishment for what happened to that baby? Does the legal system's focus on technicalities like degrees of murder and evidentiary standards sometimes result in sentences that don't match the severity of the crime? From a legal perspective, the challenges in prosecuting this case were likely significant. Without clear evidence of premeditation, without a confession explaining intent, and potentially with mental health issues or other complicating factors. Securing a murder conviction might have been uncertain. Prosecutors have to make difficult decisions about what charges they can prove versus what charges reflect the moral gravity of the crime. The case also highlights the horrific reality of infant abuse and murder. Babies are completely helpless, entirely dependent on their caregivers for survival. When those caregivers become the threat, when the person who should protect an infant instead harms them, it represents one of the most fundamental violations of human trust and responsibility. Psychologists and criminologists have studied cases of maternal filicide, mothers killing their own children, and have identified several typical patterns. Some mothers kill their children due to severe mental illness, including postpartum psychosis. Others kill out of anger or revenge, particularly in custody disputes. Still others kill to escape the burden of child rearing or due to financial stress. The method used in this case, a microwave, is so unusual that it's difficult to categorize. It suggests either severe mental disturbance or a level of cruelty that's hard to fathom. Microwaves are not a common method of homicide, and using one to kill an infant is virtually unheard of. The historical nature of this case, occurring over 20 years ago, means that it's part of Virginia's criminal history rather than current events. Elizabeth has been out of prison for many years. The infant's death certificate is a matter of public record. The case files sit in archives, a grim reminder of what happened. Including this case in our documentary serves several purposes. It provides historical context for child abuse and filicide cases in Virginia. It demonstrates how the legal system has handled such cases in the past. And it serves as a memorial to an infant who had no chance at life, who died before experiencing any of the joys or opportunities that should have been his. For those in the true crime community, cases like this are both fascinating and disturbing. They push the boundaries of what we can understand about human behavior. They challenge our assumptions about mothers and about the instinct to protect one's children. And they remind us that sometimes, the monsters are not strangers lurking in shadows, but people in seemingly normal homes. The Elizabeth Renee Ott case stands as one of Virginia's most disturbing historical child death cases. While she has served her time and moved on with her life, the memory of what happened to her infant son remains, a dark chapter in Virginia's criminal history and a reminder of the unthinkable things that sometimes occur. If cases like this affect you deeply, it may be helpful to take breaks from true crime content and to practice self-care. These stories are real, and the victims deserve to be remembered, but consuming too much dark content can take a toll on mental health. Thank you for staying with us through this difficult case. If you find value in our historical deep dives, as well as our coverage of current cases, please like this video, share your thoughts in the comments, and subscribe to Cold Case Time for more comprehensive true crime coverage. Case number 9. Nubia Williams, Starvation and Neglect in Spotsylvania. Spotsylvania County, Virginia. October 2025. Just months ago, another case of child neglect resulting in death shocked Virginia. A 4-month-old infant was brought to the hospital by his mother, Nubia Williams, unresponsive and not breathing. Despite the frantic efforts of medical personnel, the baby could not be saved. The medical examination that followed revealed a heartbreaking truth. This infant had not died from sudden illness or an unexpected medical emergency. He had died from severe malnourishment and neglect. At 4 months old, when babies should be growing, developing, and thriving, this child had been slowly starving. 4 months old. That's barely long enough to start recognizing faces, to begin smiling socially, to coo and make eye contact. This baby should have been reaching developmental milestones, gaining weight, and experiencing the beginnings of life. Instead, he was dying from lack of basic care. The investigation into the baby's death was swift and thorough. Medical examiners documented the extent of the malnutrition, the weight that was far below normal for an infant his age, and the signs of prolonged neglect. This wasn't a situation where the baby had suddenly become ill in the hours before being brought to the hospital. This was chronic, ongoing failure to provide adequate nutrition. Investigators examined the home environment, interviewed Nubia Williams, and tried to understand how a 4-month-old infant could starve to death in a modern American home. The answers they found were disturbing. The baby had not been receiving adequate feeding. Whether through neglect, indifference, or something more sinister, Nubia had failed to provide her infant son with the most basic necessity of life, food. Unlike older children who can ask for food, complain about hunger, or even find food themselves, infants are completely dependent. They rely entirely on their caregivers to recognize their needs and meet them. A 4-month-old infant cries when hungry, shows distress, and looks to his mother for comfort and nourishment. For Nubia's son, those cries apparently went unheeded. The death was ruled a homicide. This classification means that the child died as a result of another person's actions or inactions. In this case, his mother's failure to feed him. It wasn't an accident. It wasn't a sudden medical condition. It was preventable death caused by neglect. Nubia Williams was arrested and charged with second-degree murder and felony child neglect. The charges reflected the serious nature of what had occurred. Second-degree murder, while not carrying the premeditation element of first-degree murder, still recognizes that her actions resulted in her child's death and that she bears criminal responsibility. She was jailed without bond at the Rappahannock Regional Jail, where she awaited trial. The decision to hold her without bond reflected the severity of the charges and the court's assessment that she posed a risk if released. The case proceeded through the legal system, and ultimately, Nubia Williams was convicted of the charges against her. At sentencing, the court heard about the suffering her infant son had endured, the preventable nature of his death, and the complete failure of maternal duty that led to his starvation. The judge sentenced Nubia Williams to 18 years in prison, with a total sentence of 40 years, but 22 years suspended. This means she will serve 18 years behind bars if she complies with all conditions, with the additional 22 years hanging over her as a deterrent against any violations. 18 years. Her infant son got 4 months of life, much of it spent suffering from hunger and neglect. Nubia will serve 18 years for taking that short life from him. When she's released, she'll still have years ahead of her. Her son will still be dead, having never experienced childhood, adolescence, or adulthood. The case is tragically similar to the Amy FaJohn case we discussed earlier. Another Virginia mother, another child starved to death, another failure of the most basic parental duty. These cases raise questions about what's happening in some Virginia homes, about what drives mothers to withhold food from their children, and about how such situations can be prevented. In Nubia's case, the child was only 4 months old. The period of neglect couldn't have been very long before it proved fatal. This suggests that the neglect was severe and that the baby was receiving almost no adequate nutrition from the time of his birth or shortly thereafter. Postpartum depression and postpartum psychosis are real conditions that can affect new mothers and can impair bonding and caregiving. However, these conditions, while they may explain some maternal behavior, don't excuse allowing an infant to starve to death. Resources exist for mothers struggling with postpartum mental health issues, and family members, medical professionals, and social services should be alert to warning signs. Were there people in Nubia's life who might have noticed that something was wrong? Did she attend pediatric appointments where medical staff should have noticed the baby's poor weight gain and failure to thrive? Did family members see the baby and notice his condition? These are questions that often emerge in cases of fatal child neglect. Pediatricians are trained to monitor infant growth and development closely. Regular checkups in the first months of life include weight checks, feeding assessments, and overall health evaluations. A baby who is not being adequately fed will show clear signs: poor weight gain, lethargy, developmental delays. If Nubia was taking her son to regular checkups, medical professionals should have identified problems. If she wasn't taking him for checkups, that itself is a red flag. The case also highlights the vulnerability of very young infants. A 4-month-old can't speak, can't seek help, can't tell anyone what's happening. They're entirely at the mercy of their caregivers. When those caregivers fail them, the results can be fatal, and often there's no one to intervene in time. Child Protective Services in Virginia and across the country face the challenge of identifying at-risk infants before tragedy strikes. But with limited resources, heavy caseloads, and privacy concerns that limit intervention into homes without clear evidence of abuse, many vulnerable infants slip through the cracks. Mandatory reporting laws require certain professionals, doctors, teachers, social workers, to report suspected child abuse or neglect. But if a mother isn't taking her infant to medical appointments and isn't interacting with professionals who might notice problems, those reporting mechanisms fail. Nubia Williams is now in prison, beginning what will likely be close to 2 decades behind bars. Her infant son is in a grave, his life reduced to a few brief months of suffering. The Spotsylvania County community has had to grapple with another case of child death that should never have happened. As we examine these cases of mothers who've killed or fatally neglected their children, a pattern emerges. These aren't typically sudden, impulsive acts. They're often the result of ongoing dysfunction, neglect, and a failure to seek or accept help. Warning signs exist, but they're either not noticed or not acted upon until it's too late. The recent nature of this case, occurring just months ago, means it's still fresh in the minds of Virginia residents. The legal proceedings concluded recently, and Nubia Williams is just beginning her prison sentence. The case serves as a current example of the ongoing problem of child abuse and neglect in Virginia and across America. If you know a new mother who seems to be struggling, reach out. Offer help. Don't assume she's fine because she's not asking for assistance. Many mothers suffer in silence, afraid to admit they're having difficulty, worried about judgment or losing their children. Support, resources, and early intervention can save lives. For our viewers who've stayed with us through this difficult case, thank you. If you appreciate our coverage of both historical and current cases, please show your support by liking this video, leaving a comment with your thoughts on how we can better protect infants, and subscribing to Cold Case Time for continued true crime coverage that goes beyond headlines. Case number 10. Alveda Juanita Haskins, the Poison Bottle. Norfolk, Virginia. April 2024. A 3-month-old baby girl was in the care of her grandmother, Alveda Juanita Haskins. This should have been a safe arrangement. Grandparents caring for their grandchildren is a tradition as old as families themselves. Grandmothers are often seen as sources of wisdom, love, and nurturing care. But in this case, being left in grandmother's care proved fatal. The baby became sick while in Alveda's care. What seemed initially like an illness requiring medical attention quickly became a medical emergency. Despite efforts to save her, the 3-month-old infant died. The loss of a baby is always tragic, but as medical professionals examined the infant, they discovered something that transformed grief into horror. Toxicology reports revealed that the baby had lethal levels of medication in her system, specifically antipsychotic medication and cough syrup. These weren't medications that a 3-month-old infant should have been exposed to at all, let alone in quantities sufficient to cause death. The discovery prompted a homicide investigation. Investigators worked to determine how these medications had gotten into the baby's system. The answer they uncovered was disturbing and specific. Alveda Haskins had allegedly mixed her own prescription antipsychotic medication along with cough syrup into the baby's bottle. She had then fed this poison bottle to her granddaughter. The questions that arise from such an act are almost impossible to answer satisfactorily. Why would a grandmother poison her own grandchild? Was it intentional murder, a reckless act without regard for consequences, or the action of someone whose own mental illness impaired her judgment and decision-making? The fact that Alveda was taking antipsychotic medication indicates she had mental health issues that required pharmaceutical treatment. Antipsychotic medications are prescribed for serious conditions like schizophrenia, bipolar disorder, and severe depression with psychotic features. These are not casual prescriptions for minor anxiety or stress. But having a mental health condition, even one requiring antipsychotic medication, doesn't automatically mean someone will harm others. Millions of people take these medications and function normally, maintain relationships, and care for children safely. The question in Alveda's case is whether her mental illness played a role in her decision to put her medication in her granddaughter's bottle, or whether this was a calculated act for reasons we may never fully understand. The investigation took months. Evidence had to be gathered, analyzed, and presented to prosecutors who would decide what charges to file. In October 2025, more than a year after the baby's death, Alveda Juanita Haskins entered a guilty plea. She pleaded guilty to felony homicide, a charge that acknowledges she caused the death of another person through criminal action. By pleading guilty, Alveda avoided a trial and accepted responsibility for her granddaughter's death. Whether this represents genuine remorse, a strategic legal decision, or simply an acknowledgement of overwhelming evidence is unclear. The guilty plea was entered in Norfolk Circuit Court on October 29, 2025. Sentencing was scheduled for February 20th, 2026, just weeks from now as we record this documentary. The outcome of that sentencing hearing will determine how many years Alveda Haskins will spend in prison for killing her 3-month-old granddaughter. Sentencing guidelines for felony homicide vary depending on circumstances, criminal history, and aggravating or mitigating factors. Alveda could face anywhere from several years to several decades in prison. Her age, health, mental health history, and the specific circumstances of the crime will all factor into the judge's decision. The case raises important questions about allowing individuals with serious mental illness to care for vulnerable infants. Should there be screening or assessment before grandparents take on caregiving responsibilities? How do we balance family autonomy and privacy with child safety? In many families, grandparents provide essential childcare, allowing parents to work and providing children with loving care from family members. The vast majority of these arrangements work wonderfully, benefiting everyone involved. But cases like this one remind us that not every family member is suitable to care for infants, and that mental illness, instability, or poor judgment can have fatal consequences. The baby's parents have had to live with unimaginable grief and guilt. They entrusted their 3-month-old daughter to her grandmother, believing she would be safe and cared for. Instead, their baby was poisoned and killed. The trauma of such a loss, combined with the betrayal of trust by a family member, is difficult to comprehend. 3 months old, this baby had barely begun her life. She was just starting to track objects with her eyes, to make cooing sounds, to recognize her parents' faces. She would never sit up, never crawl, never say her first word. Her entire existence was reduced to 3 months, ending in poisoning by her own grandmother. The method of the killing, mixing medication into a baby bottle, shows a disturbing level of deception and premeditation. Alveda had to make deliberate choices, to take her medication and cough syrup, to mix them into the formula or milk in the bottle, and then to feed that bottle to her granddaughter. Each step was a decision point where she could have stopped, where she could have chosen differently. What was going through Alveda's mind as she prepared that bottle? Did she understand what she was doing? Did she intend to kill the baby? Or did she somehow rationalize that a small amount wouldn't hurt? Or was her mental state so compromised that she couldn't think clearly about consequences? These are questions that may be explored at the sentencing hearing. Defense attorneys typically present mitigating evidence, including mental health evaluations, to help explain, though not excuse, their client's actions and to argue for leniency. The prosecution will focus on the victim, an innocent 3-month-old baby who died a preventable death. Toxicology evidence will show exactly how much medication was in the baby's system, providing objective data about the severity of the poisoning. Medical experts can testify about the effects these medications would have had on an infant's tiny body and whether the baby suffered before death. The case is a reminder of the importance of medication safety, particularly around children. Prescription medications should be stored securely, never mixed with food or drink intended for others, and kept completely away from children. While this advice usually focuses on preventing accidental poisoning, this case shows that intentional poisoning by caregivers is also a horrific reality. For parents reading this or watching this documentary, the case underscores the importance of knowing who is caring for your children and being alert to any signs of problems. If a caregiver has mental health issues, are they stable? Are they taking their medications as prescribed? Are there warning signs of declining mental health? These aren't comfortable questions to ask family members, but they can be literally life or death issues. As we await Alveda Haskins' sentencing in February 2026, we're reminded that this case is still developing. The final chapter hasn't been written. But regardless of the sentence imposed, nothing will bring back that 3-month-old baby girl or undo the grief her parents and family must live with forever. Alveda Haskins will face a judge in just weeks. She will hear impact statements from the baby's family. She will learn how many years she will spend in prison for what she did. And then she will begin serving that sentence, living with the knowledge that she took her own granddaughter's life. This case concludes our examination of 10 Virginia mothers whose crimes have ensured they will never see freedom again, or will see it only after serving decades behind bars. Each case is unique, each victim deserving of being remembered, and each crime a reminder of the capacity for evil that can exist even in those who should embody love and protection. If you've made it through all 10 of these difficult cases with us, thank you for bearing witness to these stories. These aren't easy narratives to hear, but they're important ones. They remind us to protect the vulnerable, to take warning signs seriously, and to remember victims whose voices were silenced. Please show your support for this kind of comprehensive true crime coverage by hitting that like button one final time, leaving a comment with your thoughts on these cases or on how we can better protect children and vulnerable individuals, and subscribing to Cold Case Time so you never miss our deep dives into the cases that matter. Thank you for watching, and until next time, stay safe.